2, 1.
This Honorable Court of Appeals of Tennessee is in session.
Before we call the case, just a quick reminder, we don't anticipate any technology-related problems, but if we should have any, everybody just take a deep breath and pause, and our tech experts will get us back going. Call the case, please.
Estate of Beulah Blankenship et al. Versus Bradley Healthcare and Rehabilitation Center et al.
We'll hear from the appellant.
May it please the court, my name is Whitney Horick and I represent Bradley County, Tennessee and Bradley Healthcare and Rehabilitation Center on this Rule 10 appeal. I would like to reserve 3 minutes for rebuttal.
That'll be fine.
Thank you. The trial court deviated from the accepted and usual course of judicial proceedings by denying the defendant's motion to dismiss for 3 reasons. First, the court erroneously held that the letter attached as Exhibit 7 to the complaint satisfied Tennessee Code Annotated 2926-122 and that plaintiff satisfied Tennessee Code Annotated 2926-122 without consulting a causation expert. Secondly, the trial court improperly relied on and directly quoted from Smith versus Uten, which was designated not for citation by the Tennessee Supreme Court on February 5th of 2021. And third, the trial court failed to identify a legal basis for granting the appellee's motion for extension to file the certificate of good faith, and the appellee did not assert a meritorious basis for an extension, and therefore the motion for extension should have been denied. And therefore, the appellant is asking this court to reverse the trial court's order denying defendant's motion to dismiss and dismiss plaintiff's case with prejudice. There are a few facts that I want to make the court aware of before I get into the crux of the issues. This is a healthcare liability action related to Beulah Blankenship's residency at defendant's nursing home in June of 2019. She suffered a fall in June 2019 and subsequently passed away in July of 2019. The complaint alleged violations of the healthcare under the Healthcare Liability Act and a wrongful death claim, and attached as Exhibit 7 to the complaint a letter signed by nurse practitioner Natalie Baker. The letter is at volume 1, page 70 of the record. The letter states that Ms. Baker reviewed the records and was competent to provide opinions under Section 115 and could state there was a good faith basis to maintain the action under Section 115. The defendants timely filed a motion to dismiss, asserting that Exhibit 7 did not satisfy Section 2926-122. And 3 months after that motion was filed, the appellees filed their motion for extension. The trial court permitted the appellants to depose Natalie Baker to ascertain her ability to testify as to causation and whether she should receive sufficient records for her review of the case. Ms. Baker testified that she did not review the case for causation and was not asked to do so. She also testified that she'd never been asked to opine on medical causation and that she did have sufficient records to provide opinions on the nursing standard of care and deviations from the nursing standard of care. Her testimony is at volume 2, 296 to 300 of the record, and volume 3 at 301 to 305 of the record. 3 days prior to the hearing on defendant's motion to dismiss, Smith v. Uten was designated not for citation, and the court was made aware of this designation at the hearing. The court's order was issued in March of 2021 and demonstrated the trial court's failure to analyze the key issues in the case. The order denied the motion to dismiss and granted the motion for extension. This case presents a unique opportunity for the court because the identity and opinions of the experts supporting a certificate of good faith are not customarily discoverable unless under narrow circumstances. Because the plaintiff attached the letter of Ms. Baker to the complaint, plaintiff voluntarily disclosed the expert's identity and the scope of her opinions. Because of this set of circumstances, the court is given the opportunity to opine regarding whether the certificate of good faith requirement requires the plaintiff to consult an expert regarding causation. Exhibit 7 to the complaint, the letter by Natalie Baker, does not comply in form or substance with Section 122. The letter does not state that plaintiff's counsel consulted with an expert who provided opinions. The letter is merely addressed to Timothy Crosby with Burke, Burke, and Burke, and is signed by Natalie Baker. It is not a sworn declaration. It is not an affidavit. Section 122 requires that the plaintiff file the certificate, and the certificate of good faith must state or shall state that the plaintiff's counsel has consulted with one or more experts who provide a signed written statement that confirmed that the expert is competent under 2926-115 to express an opinion or opinions in the case, which is a clear reference to the locality rule in 2926-115B. And then in section A1B of section 122, it requires that the statement confirm that the expert believes that there is a good faith basis to maintain the action consistent with the requirements of 2926-115, which is a clear reference to the requirements set forth or elements set forth in section 2926-115A, the elements of the action that plaintiff must prove, which are standard of care, breach, and the proximate cause of the injuries. And that is where the appellee has failed to plan. The appellee did not consult an expert who could opine there was a good faith basis to assert that the alleged deviations from the standard of care caused the plaintiff's injuries.
Now, they didn't have to give that much detail in their certificate of good faith, did they?
No, Your Honor, they did not have to give that level of detail, but the fact is, based on Ms. Baker's testimony, she did not review the case for causation. So while they were not required to state that, the law requires that the expert review the case to assert there's a good faith basis to maintain the action consistent with the requirements of 115. If plaintiff had filed the form that the Tennessee Supreme Court had provided for that most of plaintiff's counsels use, we would not be here because we would not have gotten this information. But plaintiff voluntarily disclosed that information, and Ms. Baker was unequivocal that she did not look at causation. She didn't even know Ms. Blankenship's cause of death at the time that she reviewed the case.
So they gave you more information, but not all. If you disclose any, you have to disclose all.
Not that they have to disclose all, they just have to comply with the statute. The fact is plaintiff's counsel didn't comply with the statute because they did not consult with the causation expert. The third prong of 115A was not satisfied. What Ms. Baker could have testified that she looked at causation and that she did provide causation opinions, and then the argument here would be different. But the fact is that she did not review the case for causation. Now, appellants contend that the Exhibit 7 to the complaint did not strictly comply with the requirements under 122 and is equivalent to the failure to file a certificate of good faith. It's akin to the Dotson versus State case, which Judge Bennett and Frierson were on the panel for that opinion. In that case, the plaintiff filed suit in the Claims Commission against a state doctor, but attached a certificate of good faith from the circuit court case, which is regarding the same incident, but did not identify the doctor. In that case, that was the subject of the Claims Commission action. In that case, the trial court noted that there was a reference in the complaint that tracked the language of the statute, but this court found that strict compliance was required for the certificate of good faith, and the language in the complaint could not satisfy that requirement and required that the certificate of good faith be a separate document. And the letter itself does not comply with the language and therefore of the requirements of 122, and therefore we ask the court to find that plaintiff not comply with 122 and dismiss the case with prejudice. The trial court's order is also an error because it relied on Smith versus Uten. The Supreme Court had designated that case not for citation and to have no precedential value. The court directly cited to Uten in the opinion at volume 3 at pages 308 through 309. And though it states that the quote is from Hinkle, the quote is actually taken from Smith v. Uten at Penn site star 5. And the trial court also abused its discretion by granting the motion for extension. Plaintiff has not set forth any meritorious basis for the motion for extension to be granted, and the order did not cite a legal basis for granting the motion for extension. There was no good cause, excusable neglect, or extraordinary cause cited by the appellee to support the granting of a motion for extension. And the appellee's reference to the motion to amend in the in their response brief does not cure the defect, because a motion to amend cannot cure the failure to file a certificate of good faith because it must be filed with the complaint. The appellee relies on Hinkle v. Kindred in support of their argument that the letter complied with section 122. The Hinkle case is distinguishable and in some ways can support the appellant's argument, because in Hinkle, the plaintiff attached a detailed affidavit that set forth the expert's qualifications, where the expert practiced, and the specific opinions that that supported the good faith basis for a violation of the standard of care and causation. The court specifically reviewed what was in the affidavit and whether each element had been satisfied, and therefore Hinkle is instructive to this court because the letter attached to Exhibit 7 does not satisfy those elements. Therefore, we would ask the court to reverse the trial court's order denying defendant's motion to dismiss and dismiss the action with prejudice. Thank you.
Thank you, counsel. You have your time for rebuttal. We'll hear from the appellee.
Thank you, Your Honor. I'm Marvin Burke from Chattanooga. And the first thing I would like to tell the court is that one of the reasons that I believe this court allowed this appeal was that the court cited Smith against Newton, which was designated not to be cited. However, the law that the court cited, which is on page, only one time did the court cite Smith against Newton, and that's shown on page 4 of 7 of his opinion, which is on 309 of the record. He's actually quoting it, saying the same thing that is in the case of Jackson against HCA Health Services of Tennessee. It's exactly what that case says. He could have cited that case rather than Smith against Newton. He didn't. He happened to cite Smith against Newton. The argument in this case took place immediately before the Supreme Court designated this not for citation. In Jackson against HCA, it says that the court held that you don't need an expert on every issue. You only need an expert saying that there is a good faith effort or good faith basis for maintaining the suit.
Counsel, Mr. Burke, let me ask you, how can you have a good faith basis for saying there's a good faith basis for maintaining the suit if there's no expert on causation?
Because
I don't understand how you get to the good faith basis if you don't have anybody on causation.
The purpose is to weed out frivolous lawsuits. That's the purpose that that's stated in many cases. You don't need, according to the court's prior opinions, you don't need an expert on everything, every issue. You
Well,
just,
causation is kind of one of the, I mean, I don't know, if you don't have anybody on causation, how does that help weed out frivolous lawsuits? What if there is no causation? There's a deviation from the acceptable standard of professional practice, but no causation.
because there's a difference between causation and a good faith basis for maintaining the suit. You don't even have to use the witness who's giving you the good faith letter. You don't even need to use that witness at trial. You can just completely ignore that witness and use a different witness. What the court is saying.
Did you have a witness set to testify on causation?
Yes,
Had
we
you,
did.
you had consulted that witness, and is there anything in the record that says this witness was ready and available at that time?
No, there is nothing in the record about it. The issue is, and the issue is that even in Hinkle, the defendant in this case says that Hinkle supports their position. Hinkle does not support their position because they're saying it has to be an affidavit of an attorney saying that they have a letter saying that there is a good faith basis. In this particular case, we filed the letter that came from the nurse who is the expert who rendered the opinion. Now, whether she reviewed it or whether she's even qualified as an expert, it doesn't say you need an expert on every issue. As a matter of fact, you don't need an expert on every issue. The nurses can't necessarily testify on causation. What if it's a pharmacist or a physical therapist? They may not be qualified to testify on the issue of causation, but they can say.
Yeah, make sure I understand it. It's your position that as long as you have somebody who can testify that there was a deviation from the acceptable standard of care, that's sufficient.
Well,
to meet the good faith basis.
To make a good faith basis, all you need is the good faith basis. And we think that the testimony or the letter which was filed shouldn't have been first subject to cross-examination. Mr. Crosby in our office happened to file it rather than the certificate, and that he would have ordinarily signed. And because of that, they had the right to take the deposition of the nurse. Now, whether the nurse is qualified on the issue or not is a different situation. And the nurse was able to testify and file a certificate saying there was a deviation of the standard from the standard of care. Now, the previous cases say that you don't need an expert on every issue. There are other issues that come up also. There's the issues dealing with the defense, with many other issues that can arise at trial. And the only question is whether there is a good faith basis for bringing the suit.
But doesn't the statute say it has to be a good faith basis to bringing the suit, and reference the statute that says the elements which include causation?
It says pursuant to that statute, to that case, or excuse me, that statute number, that there is a good faith basis.
And that statute lists causation as one of the elements. So how come causation doesn't have to be included here.
Well, the nurse who filed it, who sent the letter, said that there was a good faith basis for bringing the suit. And that's what you need. There was never anything that said you had to have the nurse plus a physician saying that this violation of the standard of care by the nurse caused the injury. There's nothing in, and many of the cases have good faith letters from people who may not be in a position or not qualified to testify under the law as to causation. I hope I've tried to answer your question. Your Honor, that's what the Jackson case says. And it's not just me saying it, that's what Jackson against HCA says. And in the Hinkle case also is similar. Although in Hinkle, the letter gave much more information, but it doesn't say that, for instance, pharmacists, as I said previously, can't give causation on injuries that occur from pharmaceutical negligence. Physical therapists, other medical providers are not qualified. So what the statute doesn't say is that you need a witness on every issue. And what the statute and what the case says is that you don't need a witness on every issue.
Do those cases say you don't need a witness on causation?
It just says on it, yeah, well, let me just, may I read from this case?
Yes, sir.
Although Tennessee Code Annotated 29-26-122A1 requires the filing of a certificate of good faith with the complaint, it does not require that a plaintiff have, at commencement of the action, all of the expert testimony that might be needed on all issues. It merely requires proof of the plaintiff's due diligence, specifically that the plaintiff or his counsel consulted with at least one competent medical expert who provided a written statement confirming that the expert believes, based on the information available from medical records concerning the care and treatment of the plaintiff, that there is a good faith basis to maintain the action consistent with the requirements of TCA 29-26-115.
And which case are you reading from?
That's Jackson against HCA
Okay.
Health Services, 383 Southwest 3rd, 497. It's a 2012 opinion. The issue of Smith against Newton, that's the law that the trial court cited in his opinion on the motion to dismiss, was that particular language, but he cited Smith against Newton, which approves that language. And it's, the court said that the letter that was filed met those requirements. That's what the statute says. This is not the situation dealing with notice that you have to give prior to filing suit. This is the situation dealing with just good faith and good faith alone. We think that the trial judge was correct in his ruling in this particular case because the letter itself says that. Now, whether the witness who sent the letter looked at every aspect or didn't look at every aspect. That's not the issue. The issue is whether you have the letter a good faith letter, and we had a good faith letter. Unfortunately, Mr. Crosby filed it with the complaint rather than filing his own statement of good faith. We think that the trial judge should be sustained, that this case, as the law in Tennessee says, the law favors resolution of all disputes on their merits. And that was in Gibbons against Vanderbilt. And so this is not a situation, most of the cases that were cited by the defendant in this case about strict compliance were cases where they didn't file any type of certificate of good faith. In this case, we had a certificate of good faith. Now, whether the cross-examination of the witness who gave the certificate of good faith shows that the witness didn't consider every issue, that's a different situation. The question is whether there is good faith in bringing the suit. We think the trial court should be affirmed. Any other questions? I'll be happy to try to answer.
I hear none, counsel. So thank you for your argument. We'll hear from the appellant in rebuttal.
Thank you. Wow. First of all, the Smith v. Uton designation by the Tennessee Supreme Court was issued on February 5th, 2021. And the hearing on defendant's motion to dismiss was on February 8th, 2021. I wanted to clarify that for the court. I believe appellee's counsel misstated. The judge was made aware of the designation by email on the Saturday before the hearing when counsel became aware of the designation, and it is in the transcript that the court was aware of the designation. Appellants are not.
What about the nice little quote that Mr. Burke read from the Jackson case?
We're not arguing that the plaintiff needs an expert on every issue that could come up in this case. And I think the issue and the elements of the cause of action are two separate things. There are many issues. It's correct. There could be many issues, but the elements must in the least be satisfied by a good faith basis. It must be looked at by an expert to affirm that there's a good faith basis to maintain causation. That's the minimum that the plaintiff needs to satisfy prior to filing the suit. And that is to show that there is a meritorious basis for the suit and to show that the case is not frivolous. Without an expert who can say that there is evidence that the deviation from the standard of care breached, the deviation caused the injury, there's no affirmation, there's no assurance that the case has merit. Causation is just required for the case to have merit. And that Jackson case, as well as Hinkle v. Kindred, I wanted to note that both of those cases were decided before Myers v. Amisub opined that strict compliance was required with Section 122. And the Jackson versus HCA case was one in which the plaintiff did not file a certificate of good faith, and the court was looking at a constitutional challenge to Section 122.
So if the lawyer had simply attached a certificate of good faith as was attached to the amended complaint that said what it said, I've consulted with one or more experts, got written statements from them, we wouldn't be here, would we?
We would not know that there was an error. That is correct. We would not know that there was no causation expert, which I think shows the importance of this court opining that causation is required, because the error can go, or the attorney can hide behind the form that doesn't require the details. But the statute clearly requires that the expert state that there's a good faith basis to maintain the action consistent with the requirements of Section 115. Thank you.
Of course, thanks to counsel for both sides. We appreciate your briefs and your argument. I think you've made the issue very clear. If you would please recess court till our next scheduled case.
This honorable court is in recess until 2:30 p.m.